Hello and welcome to today's webinar where we're talking about domestic law and practice in Queensland. My name's Stephanie Ewart and I'm the Projects Officer at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they're the Turrbal and the Jagera people. I wish to pay my respects to elders past, present and emerging and acknowledge the important role of Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. We also acknowledge the disproportionately high rates of domestic violence experienced by Aboriginal and Torres Strait Islander peoples and the additional challenges this creates in responding to this issue. This webinar is part of a series of webinars being hosted by Community Legal Centres Queensland with generous funding of the Queensland State Government through the Victims Assist Queensland. This webinar is our very first one. The second one will be coming up on the 12th of December and we'll have Julia Morgan from Victims Assist speaking about their role in supporting victims of domestic violence on that day. If you haven't already received an invite to that webinar, please let us know and we'll make sure that you do get one. In the new year, we'll be following up with a further series of webinars exploring different parts of this topic. But for now, we're going to be joined by Samantha Kelley of North Queensland Women's Legal Service, who's going to give us an introduction to the area. I'll let Samantha tell you a bit more about herself when I hand over in a moment, but I just want to let you know today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered and they'll also be available to download from our website and from the handout section of the GoToWebinar control panel. As we go through, there's two ways you can ask questions. You can press that button that looks like a hand and we'll unmute you at the end so that you can ask your question via the microphone, or probably easier, type your question into the question box in the control panel as the questions come to you through the webinar, and we'll read your question out and ask Samantha to answer it for us at the end of the webinar. I'll now hand over to Samantha and I'll talk to you again at the end of the session. Thanks very much, Sam.
Thank you. So good morning, everyone. I hope everyone can hear me okay. This morning's topic, I realised after starting to put the presentation together, is a massive one. So there is quite a bit of information to get through this morning, and we'll try our best to get through that in as much detail as we can. So please bear with me as we're going through it. Just quickly, today's webinar will be addressing how domestic violence is defined, who can make an application for a domestic violence order, what is the basis for a temporary and a final domestic violence order, and how does the court deal with cross applications rather. So getting straight into it, particularly noting that we do have limited time, just quickly, the legislation that deals with the making of a domestic violence order as well as breaches is the Domestic and Family Violence Protection Act of 2002. It's also vital to be familiar with the relevant regulations and the rules, both of which are on the screen at the moment. So who can make an application for a protection order? Here we need to look to Section 25 of the Act. There are only certain people who can apply for a domestic violence order, and that's of course listed on the screen there. Primarily in practice, we will see the aggrieved being the person who seeks to be protected or is sought to be protected, or police officers applying for domestic violence orders. A child can be an aggrieved or in fact a respondent to an application, however, only if there's an intimate personal relationship or an informal care relationship between the child and the respondent or aggrieved. So there can be no application if the child and the respondent or aggrieved are in a family relationship, so i.e. where they're relatives of each other. And we'll discuss these relationship types shortly. So applying for a protection order, leaving aside the use of police protection notices by the police, and you can refer to Part 4 of the Act regarding the police functions and powers, the applicant is required to make a written application for a protection order. And I've got a link there, which hopefully works, to the form DV01, which is the application form. In addition to having the power to make a protection order where an application has been filed, the court also has the power to make protection orders or to vary protection orders in a couple of other circumstances, including firstly, upon conviction of a person for a domestic violence offence. Here we can look at section 42 of the Act, which allows the court on its own initiative to make or vary a protection order against an offender. Please note though that section 42 subsection 4 requires the offender, prosecution and aggrieved to have been given reasonable notice to present and prepare evidence and make submissions regarding the making or variation of the protection order. The Children's Court also has a similar power, and you can have a look at section 43 of the legislation for some further information and guidance around that. I think these are really important points to bear in mind, including in practice. I know our service is attempting more and more to liaise with the police and the DPP, where we're assisting a woman who has been the victim of a domestic violence offence where she wants to make or vary a protection order. We are trying where we can to get the police and the DPP on board with making an application under section 42 for the making or variation of a protection order upon conviction of the DV offence. Moving along to service of the application, once it's filed, we're required to serve the application personally on the respondent. Thankfully, this is a task for the police rather than for the aggrieved. Please note, though, that section 36 of the Act does allow the applicant to seek to have the application listed before the court before service occurs for the purposes of the court determining whether a temporary protection order will be made, and we'll be going through the requirements of the making of a temporary protection order shortly. So when can the court make a protection order? So we need to look at the requirements under section 37 here. There are 3 elements to making a protection order on a final basis, I should say. The court must be satisfied that a relevant relationship exists between the aggrieved and the respondent, and that the respondent has committed domestic violence against the aggrieved, and that the protection order is necessary or desirable to protect the aggrieved from domestic violence. And again, all 3 of those elements must be satisfied before the court can make a protection order. And we're going to have a look at each of those 3 elements separately and break it down for you. So firstly, looking at what is a relevant relationship. Here we need to look to Division 3 of Part 2 of the Act. Firstly, we need to look to Section 13, which defines what a relevant relationship is and is really the starting point for determining whether the aggrieved is in a relevant relationship with the respondent. So what does Section 13 say? It defines a relevant relationship as an intimate personal relationship, a family relationship, or an informal care relationship. And we then need to look at the further sections under Division 3 to determine whether the parties involved in our case are in one of the above relationships. So we then look to Section 14 of the Act in terms of defining whether the parties are in an intimate personal relationship. An intimate personal relationship is broken down into including spousal relationships, an engagement relationship, or a couple relationship. We then need to look at the further sections of the Act to define those particular relationships to determine whether the parties are in an intimate personal relationship for the purposes of defining whether they're in a relevant relationship. So we're going to look at spousal relationships, engagement relationships, and couple relationships now, and we'll discuss each of them separately. So firstly, turning to the question of what is a spousal relationship. Here, Section 15 of the Act states that a spousal relationship exists between spouses, which is rather helpful. The section specifically notes that a reference to a spouse includes a de facto partner. The section then goes on to define that a spouse of a person includes a former spouse of the person and a parent or a former parent of a child to the person. So basically, to summarise, a spousal relationship will exist between a current and former husband and wife, current and former de facto partners, and a parent or former parent of a child. So looking quickly at what is a parent or who is a parent, we need to look here at Section 16. So a parent is defined under that section as the mother or father of a child and anyone else other than the chief executive for the purposes of child protection orders having or exercising parental responsibility for the child. It does not include a person standing in the place of a parent on a temporary basis, nor does it include an approved foster carer for the child or an approved kinship carer for the child. It's important to understand that a parent of an Aboriginal child or a Torres Strait Islander child includes a person who, under Aboriginal tradition or island custom, as may be applicable, is regarded as the parent of the child. So there's a broader definition there in terms of the parent of an Aboriginal or Torres Strait Islander child. So we've had a look at the definition of a spousal relationship. We're now going to have a look at the definition of an engaged relationship. Quite simply, Section 15 defines an engaged relationship as a relationship existing between two persons if the persons are or were engaged to be married to each other. So that's quite a simple definition. Moving then on to the definition of a couple relationship. So a couple relationship is defined under Section 16 as existing between two persons if the persons have or had a relationship as a couple. Subsection 2 goes on to state that in deciding whether a couple relationship exists, the court may have regard to the following circumstances, including the circumstances of the relationship, including the degree of trust and the level of the dependence on and commitment to each other, the length of time for which the relationship has existed or did exist, the frequency of contact between the parties, and the degree of intimacy between the persons. Subsection 3 goes on to state that notwithstanding subsection 2, the court may consider various factors which are listed in that subsection in deciding whether a couple relationship exists. And you can have a look at that subsection, but in summary, it includes considerations regarding whether the trust, dependence, commitment is or was of the same level, the financial dependence between the parties, property ownership between the parties, joint bank accounts between the parties, the existence of a sexual relationship, and the exclusivity of the relationship. So there's a number of factors for the court to consider when determining whether the parties are in a couple relationship. So remember, to establish that the parties have a relevant relationship, we need to prove that the parties have either an intimate personal relationship, which we've just gone through, looking at the definition of spousal relationships, engagement relationships, and couple relationships, or in a family relationship or an informal care relationship. And we'll look at those last two types of relationships now. So what's a family relationship? We need to refer to Section 19 of the Act here. A family relationship exists between two persons if one of them is or was the relative of the other person. A relative is a relative of a person or someone who is ordinarily understood to be or have been connected to the person by blood or by marriage. Importantly, the Act provides a very helpful list of examples of a person's relatives and former relatives, which can be found under subsection 2 of Section 19. It's very important to have a read of those examples because they're incredibly useful in practice and something that I will refer back to myself from time to time if I've got a tricky question about whether there's a family relationship between the aggrieved and respondent. Also importantly, subsection 4 goes on to provide for a wider definition of a relative, which may apply to Aboriginal and Torres Strait Islander people, members of certain communities with non-English speaking backgrounds, or people of particular religious beliefs. So now, what's an informal care relationship? Look to sections 20 of the Act here, which defines an informal care relationship as that existing between two persons if one of them is or was dependent on the other person, the carer, for help in an activity of daily living. It's important to note that such a relationship doesn't exist between two persons if one person helps the other in an activity of daily living under a commercial agreement, which can include help provided by a voluntary organisation where no fee is paid by the person, but excludes arrangements where one person receives a pension or allowance for the help provided. In practice, an important tip is to, when dealing with cases involving a care relationship, an informal care relationship, it's important to consider the care arrangements for the aggrieved person if the respondent involved is or was his or her carer. It's important to bear in mind that the making of a domestic violence order may remove the carer from the aggrieved's life if there are certain conditions placed on the order, such as a condition which would restrict the respondent from residing with the aggrieved or from having any contact with the aggrieved. It's important to understand that the respondent may be their only source of help, so there'll be some competing issues here. There'll be issues of domestic violence and whether the court can make the domestic violence order and should make the domestic violence order, but also issues around how we get some care and assistance for the aggrieved person involved. So it's very important to take that into consideration in practice. So just a quick case study regarding the question of relevant relationship, and I'll just run through the facts quickly. Basically, Anna comes to seek some legal advice about an application served on her and is the respondent. The aggrieved is Anna's now former husband's partner, Betty. So Anna's ex-husband is Wayne. Wayne is now in a de facto relationship with Betty, and Betty's applied for a domestic violence order against Anna. Now, Anna and Wayne have a couple of kids together and they have them on a week-about basis. Betty, as the de facto partner, assists Wayne with the care of the children, taking them to and from school and conducting the occasional changeover with Anna. Betty alleges that she was subjected to domestic violence committed by Anna at a changeover, which she attended in place of Wayne. Betty alleges that Anna's also been sending abusive emails to her. And the question is, are Anna and Betty, as the aggrieved and respondent, in a relevant relationship? We need to consider, of course, the meaning or the definition of relevant relationship under Section 13, which we've just gone through. So do Anna and Betty have an intimate personal relationship, a family relationship, or an informal care relationship? So in my view, they do not have an intimate personal relationship. They are not, and nor were they spouses or de facto partners, and they do not have children together. They also don't have a family relationship. They're not relatives of each other. So in my view, they're not in a relevant relationship with each other. So that's just a bit of a practical example based upon a scenario which we can and have seen in practice. So let's go back now to the question of when the court can make a protection order. So we've gone through the definition of a relevant relationship, and we'll now move on to the definition of domestic violence, remembering that all three elements must be satisfied before the court can make a protection order. So what is domestic violence? We must refer to Section 8, which defines domestic violence. It's defined to include behaviour which is physically or sexually abusive, is emotionally or psychologically abusive, is economically abusive, is threatening, is coercive, or in any other way controls or dominates the second person and causes the second person to fear for their safety or that of someone else. Now, rather helpfully, subsection 2 of section 8 goes on to provide further guidance around what domestic violence includes. I won't read that out, but of course that's in the slide, and you can refer back to section 8 for some further guidance around the definition of domestic violence. It's also important to note that section 9 defines associated domestic violence, which is relevant to when the court is required to consider whether to name a child, a relative, or an associate on a domestic violence order. Section 10 defines when a child is exposed to domestic violence. Section 11 defines emotional or psychological abuse, which of course is a form of domestic violence. And Section 12 defines economic abuse. And it's important to have an understanding of those sections and to read through them. So again, going back to the elements of when the court can make or the requirements for when the court can make a protection order. Moving now on to lastly, the question of the determination of whether it's necessary or desirable to protect the aggrieved from domestic violence. So we need to have a look at section 37, subsection 2, which states that in deciding whether a protection order is necessary or desirable to protect the aggrieved from domestic violence, the court must consider the principles under section 4. And if an intervention order has previously been made against the respondent and the respondent has failed to comply with the order, the respondent's failure to comply with that intervention order. And in addition, the court's required to consider if an intervention order has previously been made and the respondent has complied, the court may consider the respondent's compliance with the order. We will be touching briefly on intervention orders, what they are and how they work very shortly. Subsection 3 goes on to state that the court must not refuse to make a protection order merely because the respondent has previously complied with an intervention order. So it's important to have regard to section 4, which outlines the principles of the Act when looking at whether it is necessary or desirable to protect the aggrieved by making the domestic violence order. I won't, in the interest of time, I won't read through section 4, but I have set it out on the slides there for you to read. It is important to read and understand those principles, not only in terms of the question of is the order necessary or desirable, but also in terms of your general practice in the area. So section 4 goes on, the principles go on in the next slide here. So continuing on the topic of whether the order is necessary or desirable to protect the aggrieved, I wanted to make mention and refer to the bench book, the Domestic and Family Violence Protection Act bench book. It provides some useful case law in relation to the meaning of necessary or desirable, and I think that the bench book itself is a really helpful tool in the practice of domestic violence. So I just wanted to go through some of the cases quickly that have been referred to in the bench book in terms of this question of whether the order is necessary or desirable. So in the first case here, we can see that the court states that a court may find it desirable rather to make an order without finding it to be necessary. So one example, of course, might be where the perpetrator needs to be held accountable. The court went on to say that a court may find it necessary to make an order without finding it to be desirable. And one example might be where a court finds it necessary despite the wishes of the aggrieved who stands opposed to the making of an order. So an aggrieved might oppose an application brought by the police. However, the court may, upon hearing, find that it's necessary to make the order without finding it to be desirable in circumstances where the aggrieved is opposed to the making of that order. Then moving on to the case of MDE versus MLG and the Queensland Police Service, the judge here states in paragraph 55 that the necessary or desirable element requires a three-stage process. Firstly, the judge said that the court must assess the risk of future domestic violence between the parties in absence of any order. So the judge went on to say that there must be evidence to make factual findings or to draw inferences of the nature of and prospect that the domestic violence may occur in the future, and said that this will depend upon the particular circumstances of the case. The judge said that the relevant considerations may include evidence of past DV and conduct, genuine remorse, rehabilitation, medical treatment, psychological counselling, compliance with any voluntary temporary orders, and change of circumstance. The judge went on to say that there must be more than a mere possibility or speculation of the prospect of domestic violence. Secondly, the judge said that the court must assess the need to protect the aggrieved from that domestic violence in absence of an order, so in absence of an order being made. The judge went on in his decision to say that the relevant considerations may include evidence of the parties' future personal personal relationships, their places or residence and work, the size of the community in which they reside, and the opportunities for direct and indirect contact and future communication, including contact and communication in relation to their children. Thirdly, the judge said that the court must consider whether imposing a protection order is necessary or desirable to protect the aggrieved from domestic violence, and basically said that the court must consider the principles under Section 4, which we've just touched on. Finally, the court said that if the court is satisfied of the other preconditions of a relevant relationship and domestic violence, the court may exercise its discretion to make a protection order imposing appropriate prohibitions or restrictions on the behaviour of the respondent, which are necessary or desirable to protect the aggrieved from domestic violence. Interestingly, in the next case of ACP, the judge considered the three-stage process, which we've just gone through this morning. The judge here said, in my respectful opinion, whilst Judge Morzone identified a three-stage process, which His Honour considered satisfaction under Section 37(1)(c) required, His Honour's decision should not be understood to mandate those particular stages or steps. As His Honour observed at paragraph 52, the use of the phrase necessary or desirable invokes a very wide and general power and should be construed in a similarly liberal manner to enable the court to properly respond and, if appropriate, tailor an order to protect a person from domestic violence. The judge went on to say that the requirement under Section 37(1)(c) that the court must be satisfied that the protection order is necessary or desirable itself confers a discretion. It is a discretionary determination to be made in the exercise of a further discretionary decision, that is, whether to make a protection order. So it's clear that there's a large amount of discretion in terms of the decision about whether the protection order is necessary or desirable to protect the aggrieved from domestic violence. And of course, every case will be different and we'll turn on the facts of that case. Turning now to the duration of a protection order, here we must look to Section 97, I should say, of the Act, which states that a protection order continues in force until the date which is stated by the court under the order as being the expiry date, or if there's no date stated, a day that is 5 years after the day the order is made. The court has the power to make a protection order which continues in force for any period that the court considers to be necessary or desirable to protect the aggrieved from domestic violence or a named person from associated domestic violence, but for a period of less than 5 years, only if the court is satisfied that there are reasons for doing so. When deciding the duration, the paramount principle is that the safety, protection, and well-being of people who fear or experience domestic violence, including children, is paramount. So basically, 5 years is the maximum period that the court can make an order for and is the standard, bearing in mind that the court can only make an order for a period of less than 5 years if the court's satisfied that there are reasons for doing so. Importantly, under the legislation, if the court makes an order for a period of less than 5 years, then the court is required to give reasons for the making of the order. So turning now to the making of a temporary protection order, we need to have a look here at section 45 of the Act. Here, the court can make a temporary protection order against the respondent only if the court is satisfied that a relevant relationship exists between the aggrieved and respondent. And of course, we've touched this morning on the definition of a relevant relationship. And also, secondly, if the respondent has committed domestic violence. And of course, we've gone through the definition of domestic violence this morning. However, there is an additional requirement that must be satisfied if the temporary protection order is sought before the respondent is served with a copy of the application, remembering that I said earlier that the court can list the matter for the determination of a temporary protection order prior to service. So we must look here to section 47 of the Act, which states that the court may only make a temporary order before service if the court is satisfied that the making of the temporary order, despite the respondent having not been served with the application, is necessary or desirable to protect the aggrieved or another person named in the application from domestic violence. So there's a higher standard that must be reached before the court can make a temporary order before service. Turning now to the making of a protection order by consent. We should have regard to section 51 of the Act. If the parties consent to the making of an order or the variation of an order, the court has the power to make an order, but only if the court is satisfied that a relevant relationship exists between the parties. It's important to also note that the court can make an order by consent without being satisfied as to those matters mentioned in section 37(1)(b) or (c) regarding a final order, or section 45(1)(b) regarding a temporary order, which essentially means that the court doesn't need to be satisfied that there's been domestic violence or that an order is necessary or desirable in the case of a final order being made by consent, or that there's been domestic violence in the case of a consensual temporary protection order. The court would merely need to be satisfied of the existence of a relevant relationship. It's also important to note that the court can make a consent order whether or not the respondent admits to any or all of the particulars of the application. One important note regarding circumstances or applications involving a child as the respondent, the court can only make an order if it is satisfied of the requirements under section 37 or 45 as applicable, depending of course upon whether it's an application for a final or a temporary order. Also an important note that the court can refuse to make or vary an order by consent if the court believes that doing so may pose a risk to the safety of the aggrieved, a named person, or any child affected by the order. In practice, I can't say that I've personally seen that occur, but the Act does provide for the court to refuse to make or vary an order by consent in those circumstances. Moving on to the naming of a child under an order. The court may name a child in a domestic violence order. I'll start that again. The court may name in a domestic violence order a child of the aggrieved or a child who usually lives with the aggrieved if the court is satisfied that naming the child is necessary or desirable to protect the child from associated domestic violence or being exposed to domestic violence committed by the respondent. Now, remember that Section 9 defines associated domestic violence and Section 10 defines when a child is exposed to domestic violence. Basically, associated domestic violence is domestic violence against a child, and a child is considered to have been exposed to DV if the child sees or hears domestic violence or otherwise experiences the effects of the domestic violence. How do we name an associate or a relative on a protection order? Section 52 of the Act states that the court may name in a domestic violence order a relative or an associate of the aggrieved if the court is satisfied that doing so is necessary or desirable to protect that person from associated domestic violence. Again, remembering Section 9 defines associated domestic violence, and associated domestic violence against a relative or an associate is basically domestic violence against that person. Moving now to the conditions that can be placed on a domestic violence order once made. we need to have regard to sections 56 to 67 of the Act. Now, there are mandatory conditions which must be on all orders. So where we have an order where we have an order, the mandatory condition which must be on that order will state that the respondent must be of good behaviour towards the aggrieved and not commit domestic violence against the aggrieved. If we're naming an adult person on the order, the mandatory condition which must be included will state that the respondent must be of good behaviour towards that named person and must not commit associated domestic violence against the named person. And moving on, if there's a named child, the order must state that the respondent must be of good behaviour towards the child and must not commit associated domestic violence against the child and must not expose the child to domestic violence. In addition, the court has the power to include additional conditions. However, those additional conditions can only be included if the court is satisfied that imposing the condition is necessary or desirable to protect the aggrieved from domestic violence, or a named person from associated domestic violence, or a named child from exposure to domestic violence. So the court will consider whether each additional condition is necessary or desirable. And these conditions might include, for example, conditions which would prohibit the respondent from having contact with the aggrieved or from following or approaching the aggrieved, just as a couple of quick examples. It's important to understand that the court must consider whether to impose an ouster condition in relation to the aggrieved's usual place of residence. That's a requirement under the legislation. The court can also include exceptions to the condition. So, for example, an order might stipulate that the respondent is not to have any contact with the aggrieved. However, if the parties have children together, we'll usually see some exceptions to that condition, if it's appropriate, of course, but those exceptions would allow for certain contact in relation to the children or for the purposes of, for example, attending changeovers as agreed to or as ordered by the court. And each exception is drafted by the court based upon, well, what's appropriate, but also what are the needs of this particular family or these parties. Turning particularly to the ouster conditions, have a look at section 63. So an ouster condition is a condition which prohibits the respondent from remaining at the premises and or entering or attempting to enter the premises and or approaching within a stated distance of the premises. Now, this can include premises in which the respondent has a legal or equitable interest, premises where the aggrieved and respondent live together or have previously lived together, and premises where the aggrieved or named persons live, work, or frequent. So the definition is quite wide. Section 64 outlines the additional considerations for the court when determining whether to make an ouster condition in relation to the aggrieved's usual residence. And in the interest of time, I'll simply just ask that we just have a look at that because we don't have the time today to go through that in detail. Section 65 requires the court to consider imposing a return condition if an ouster condition is made. So this is a condition which would allow the respondent to return to collect stated personal property or to remain at the premises to remove stated personal property before leaving the premises. So cross-applications. Cross-applications are basically a second application made between the same parties, so the same aggrieved and respondent. Under the legislation, the parties are required to disclose the existence of cross-applications to the court, so the court's aware that there are two applications in play. Section 41C requires the court to hear cross-applications together unless the court considers that it is necessary to hear the applications separately for the safety, protection, or well-being of the persons named as the aggrieved to the original application, the original protection order, or the cross-application, as may be the case. Now, we ran very quickly through the principles of the Act under Section 4, but please note that Section 4 does state that that the person who is most in need of protection should be identified by the court where there are conflicting allegations or indications that both parties are committing domestic violence. In practice, it is certainly possible for the court to make cross orders between the parties where there are cross applications, but it is important to note that under the principles, the magistrate is required to identify the person who is most in need of protection. So intervention orders, I mentioned earlier that we would touch on what these are. So have a look at Division 6, Part 3 of the Act. An intervention order is an order that requires the respondent to attend either or both of an aggrieved intervention program, which is provided by an approved provider, or counselling provided by an approved provider. An intervention order can only be made with the consent of the respondent. It cannot be imposed upon him or her without their agreement. After the intervention order is made, the court provides a copy to the approved provider, who then assesses their suitability to participate, taking into consideration a number of factors, including the respondent's character, personal history, language skills, any disabilities, psychiatric or psychological conditions, or drug and alcohol problems of the respondent. Also the effect of the above matters on the respondent's ability to participate in group counselling, and any other relevant matters. If the respondent's deemed to be unsuitable to participate in the program or counselling, the provider is required to give the court and the police a notice which states so. Now, if the respondent breaches an intervention order, the provider must give the court and the police a notice outlining the date and nature of the contravention, unless the breach is minor and the respondent takes the necessary steps to remedy the contravention or is otherwise substantially complied with the order. Now, upon completion of the program or counselling, the provider must give the respondent, the court, and the police notice of the completion by the respondent. I wanted to touch briefly on some issues concerning family law orders. Under the Act, specifically Section 77, a person who applies for a domestic violence order or a variation is required to inform the court of the existence of a family law order between the parties and to provide a copy of that order to the court, assuming, of course, that they're aware in the first instance of the existence of the order. Now, under Section 78 of the Act, the court must have regard to any family law order, which the court is aware of course, and if the order allows contact between the respondent and a child that may be restricted under the proposed domestic violence order or proposed variation, the court must consider whether to exercise its power under the Family Law Act to revive, vary, discharge, or suspend the family law order. If the court is considering whether to do so, the parties must have a reasonable opportunity to present evidence and to make submissions about the exercise of this power, except in the case of a decision to make a temporary protection order. Moving now on to the variation of domestic violence orders. Both a final and a temporary order can be varied. A variation application can be made by an aggrieved, a respondent, a named person, an authorised person for the aggrieved, a person acting under another act for the aggrieved, respondent or named person, or a police officer. Now, the applicant can seek to vary any aspect of the order, for example, a condition of the order, the duration of the order, and or the persons named on the order. However, a named person can only seek a variation regarding themselves, so they can't seek to make variations regarding the aggrieved, for example. And again, there's a written application that needs to be filed and served, and that's Form DV4, and there's again a link which should hopefully work in the PowerPoint. Still on the topic of variations, specifically now a temporary protection order or a temporary variation order, have a look at Section 48, which states that the court may make a temporary protection order if the court adjourns an application to vary an existing domestic violence order, only if the court is satisfied that the temporary order is necessary or desirable to protect the aggrieved, another person named in the first order, and or a person sought to be named on the order under the current variation application from domestic violence or associated domestic violence pending a decision. So pending a final decision about whether to vary the existing order. Just quickly, I wanted to touch on the issue of costs. Section 157 of the Act is the relevant section here. Basically, each party is required to bear their own costs associated with a domestic violence application. However, the court does have the power to award costs against a party who makes an application that the court hears and decides to dismiss on the grounds that the application is malicious, deliberately false, frivolous, or vexatious. Now, basically, there are limited circumstances, as we can see, in which the court can make a costs order, but there are some grounds on which those cost orders can be made, and it's important to be aware of those provisions. So just in summary, just a couple of important take-home points from this morning's presentation. Please, of course, make use of the Act, the rules and the regulations. They're something that I refer back to all the time in my day-to-day practice to make sure that I'm getting it right. Have a read of the bench book, another fantastic resource. If I'm feeling a little stumped, I'll go back to that to see if I can get any guidance from the bench book. And remember the principles of the Act. I think it's really important to be guided by those principles in our practice. Importantly, another issue that we haven't had the time to get through or to talk about today is the fact that a client who seeks advice from us about a domestic violence matter is likely to have not only legal issues but non-legal issues and matters which need to be addressed. And it's important that we're making appropriate referrals to DV services, financial counsellors, counsellors, psychologists, psychiatrists, mediation services, Centrelink, and housing and accommodation services. So it's important to make sure that all of those non-legal issues are addressed as best we can by making the appropriate referrals. And I guess it's important to make sure that we're aware of who those services are, who those people are who can assist with these non-legal issues in our own communities. So today we've provided an overview of the DV legislation in a very short period of time. And of course, there's many other aspects to the legislation and the court processes, such as the respondent's options, breaches of the order, evidence at the hearing, impacts of an order on the respondent in terms of the weapons license, parenting proceedings, and so forth. We just haven't had the opportunity to go through that today with the time that we had. And it's important for those not practicing in the area of domestic violence to seek further training and guidance around those matters and issues. So that's the end of my presentation. I might hand back over to Stephanie to perhaps take any questions if we have any this morning.
Thanks very much, Samantha. We do have some questions. The first question we have from Paul: how long in the past can alleged domestic violence behaviour of the perpetrator have occurred?
Well, typically, if I'm preparing if I'm preparing material for an application for a protection order, I'm trying to get as much evidence as I can about the historical domestic violence in an effort to establish that there's a pattern of behaviour here. I'll be focusing quite heavily on what's happening in more recent times, but I do like to show that pattern of behaviour and that background for the magistrate so that he or she has that there. And I think that's particularly important in terms of the question of necessary or desirable, remembering we need to not only establish that the respondent has committed domestic violence, but also that it's necessary or desirable to protect the aggrieved from domestic violence.
Great detail, thanks, Sam. The next question is about a relationship between a foster carer or youth worker and a child in care. The question from Mai is that an informal care relationship?
That's a very good question, and I'm actually just flicking through myself because that's a sort of question that I would go back to the Act on in practice. So if we have a look at section 16 and the definition of a parent, subsection 2 states that a parent of a child does not include a person standing in the place of a parent of the child on a temporary basis or an approved kinship or foster care of the child.
That sounds like a good answer.
I think that's, yeah, basically the answer.
I suppose it might depend somewhat on the exact arrangements of the foster care or what the youth worker is actually doing. The devil might be in the detail there a little bit.
Yes, that's right. And I think it's perhaps something to look at a little more closely if that was the circumstances in practice.
A couple of questions about ouster orders, whether it's difficult to persuade a court to make them or whether they're made routinely in conjunction with no contact orders to allow an aggrieved to stay in their home.
I think much depends on which location we're practicing and which magistrate we're appearing before. So certainly here in Townsville, I'm seeing ouster orders made on a regular basis. But I appreciate that every magistrate is different, every location's different, and of course the facts of every application are different. So I think it's very much up to the discretion of the magistrate. Of course, as we went through earlier, it's a requirement to consider an ouster order, but I can't actually speak to whether in practice that happens across the board on each and every application.
The next question might have a similar answer in relation to cross-examination. Is it still being allowed by magistrates despite the legislation, and what can you do about that?
Again, similar answer, much depends on where we're practicing and what the magistrate's practices are, bearing in mind that it's at the discretion of the magistrate. Of course, we should have regard to section 150 and 151 regarding who are protected witnesses and the restrictions on cross-examination in person of a respondent where he or she is not represented by a lawyer. I think that there are certainly, there's obviously scope there to argue that the respondent should be restricted from cross-examining the aggrieved, or that other practical steps can be taken to make things arguably a little easier, such as having the aggrieved give evidence by video link from another room. But again, it will come down to the discretion of the magistrate on the day, and perhaps it's useful if we're not practicing in the area of DV predominantly to get some advice or guidance from those who are practicing in that area, or from counsel practicing in that area.
Good idea, thank you. Another question has come in about making orders without the aggrieved consent, particularly can a court make a full order, which I guess means with a full suite of conditions. But can you talk to us a little bit about that situation where I guess it would be a police application, but the
police application
doesn't want the order to be made?
Yeah, this is a problem that, and a scenario, I guess, that arises quite commonly in practice. Basically, the long and the short of it is, yes, the magistrate does have the power to make an order without the consent of the aggrieved, and yes, it would be a police application where that would arise. Remembering that what we said earlier is that the court needs to be satisfied of a relevant relationship, of domestic violence on the part of the respondent, and of the fact that the order is necessary or desirable to protect the aggrieved from domestic violence. There's no requirement necessarily that the aggrieved must or should be consenting to the order before it's made. And it is in practice a problem that we are seeing, certainly here in Townsville, I've no doubt across the state, and it's a challenging one when we're dealing with clients, and sometimes we are having to look at how can we get the aggrieved assistance with, for example, caring with her children. She might be opposing to the order because the respondent is the father of her children and she wants him to be able to help with that. And those submissions can be made to the court, but ultimately the consent is not required.
Thank you. The next question is about applying for an extension of time on a domestic violence order. where, for example, there might not have been any contraventions, but the aggrieved makes that application for a further term nonetheless. Can you tell us a little bit about how that might play out in a court?
It's certainly possible, of course, to apply for an extension in those circumstances, and the magistrate will consider it on its own facts, will consider the application on its own facts. I would suggest, generally speaking, that it could be quite a bit more difficult to seek an extension in circumstances where there's been no further domestic violence or contravention of the order post the making of the original order. But again, every application will need to be considered on its own facts.
Thank you. We've also had a question from Jeanette, which is outside the scope of this presentation, asking about the legal responsibility for a workplace manager in supporting employees, both victim and perpetrator of domestic violence. It's outside the scope of what Samantha has covered for us today, but we do have a webinar coming up that will cover this for us later in the new year. So please keep an eye out on our website and in our materials for our upcoming schedule of webinars. A reminder that our next webinar is at 11 a.m. on the 12th of December, when Julia Morgan from Victims Assist will be talking to us about the role of Victims Assist Queensland. But please let me thank Samantha for her excellent presentation today. We're already having comments coming through congratulating you, Sam, on an excellent presentation. Thank you very much.
Not a problem at all. We're more than happy to help.
At the end of this webinar, everybody, there's going to be a short survey pop up on your screen and via an email link. Please consider filling out that survey for us. It assists us to tailor information and future webinars to you and to evaluate the service that we're providing here. I'll now end the webinar.